meeting with distinguished representatives of the European Commission, from the Commission on Children, and Turnus of India, and from various parts of Asia's indigenous world. This is not a part of the world that I'm intimately familiar with. I've only been to Asia a few times. My first time in India, but I'm very glad to be here and eager to learn more about the situation of indigenous peoples in Asia. What I'd like to focus on in my remarks today is precisely on the UN Declaration on the Rights of Indigenous Peoples and what it represents for national institutions on the rights of indigenous peoples. My basic point is that the Declaration represents a new set of understandings globally that should shape the functioning of national institutions on the rights of indigenous peoples, both in their internal operations and in their relationships with indigenous peoples. As Suhas said, I was involved in the development of the Declaration on the Rights of Indigenous Peoples, along with many other representatives of indigenous peoples and organizations and experts on indigenous peoples' rights. I had the privileges of getting to know Suhas during that process in Geneva and other forums. And what I want to emphasize about this process is that the Declaration really does represent the aspirations of indigenous peoples themselves. It's not simply a statement of rights and obligations that comes from the United Nations without the input of indigenous peoples. Indeed, it is grounded on the input of indigenous peoples based on a process that took place over almost 3 decades. It was in the mid-70s that indigenous peoples started to appeal to the United Nations, having not gotten sufficient responses from governments at the domestic level, having seen their problems gone unanswered over long periods of time, and having projected a different model of their existence within the states in which they live, a model that rejected simply becoming assimilated into the dominant systems, and certainly a model that rejected the kind of ongoing and continuous oppression that indigenous peoples had suffered for centuries and have suffered for centuries. And so it was with this intention of promoting a new relationship with states, a new relationship with the world outside of indigenous communities, that indigenous peoples' representatives started appealing to the United Nations in the 1970s. And that resulted initially in a new institution focused on the rights of indigenous peoples, the Working Group on Indigenous Populations. And that working group on indigenous populations, I'm sure some of you are familiar with, had as one of its primary tasks developing new standards concerning the rights of indigenous peoples. And one of the innovations of this working group was that it invited the participation of indigenous peoples in its work. And so on an unprecedented scale in the history of the United Nations, we had a non-governmental entities, organizations, and individuals participating in standard work of the United Nations. And these were indigenous peoples in this case. So indigenous peoples really forged a new precedent within the United Nations in the level of non-governmental participation. As you know, the United Nations is made up of states, and so most of its deliberations are among representatives of states. It has opened up its doors to some extent to non-governmental organizations, but that participation over the history of the United Nations has been fairly limited. The Working Group on Indigenous Populations went a step further and opened its doors to virtually any indigenous representative that could arrive at the meetings of the Working Group in Geneva. And so it was there that we saw indigenous peoples make alliances among each other, friendships, and that carried themselves through time. And with those alliances, strategic steps were taken in order to push the agenda of indigenous peoples through the United Nations system, focusing on the development of a new instrument, a declaration that would proclaim indigenous peoples' rights. And it was on September 13, 2007, just a little over a year ago, that this process culminated in the adoption by the UN General Assembly of the United Nations Declaration on the Rights of Indigenous Peoples. Really, I think, a monumental achievement by indigenous peoples, an achievement that was in doubt up until really the very last days of the adoption of the Declaration. I think many of us thought up until those last few days that, well, we might be another 10 years or even 20 years in seeing a declaration adopted by the United Nations because of some of the difficulties that many states still had with provisions of the declaration. But these difficulties were overcome, and ultimately we saw for the most part, overcome. And ultimately we saw the United Nations General Assembly by an overwhelming majority of member states voting in favor of the declaration. Indeed, the vast majority of states from the Asian region voted in favor. None voted against. Well, New Zealand and Australia voted against it for reasons that I'll go to in a little while. But none outside of Australia, New Zealand, and the Pacific Asian region voted against it. A number abstained, but India, for example, did not abstain. It had voted in favor of the declaration. A significant piece of information, I think, to keep in mind, that all these states of the region essentially affirmed the principles of the declaration, affirming the basic rights of indigenous peoples that are included in that document that were promoted by indigenous peoples themselves. Now, what does the declaration say? First of all, the declaration should be understood to be grounded in basic human rights principles. It is not a statement of new rights of indigenous peoples in the sense that it creates rights that aren't available to other segments of humanity. What it does is it takes basic human rights principles, contextualizes them for the particular circumstances of indigenous groups that have suffered histories of colonization, oppression, that claim rights to continue their bonds with ancestral land and continue their communities intact, and within that context affirms these basic human rights as rights that apply to indigenous peoples fully and equally in relation to other parts of humanity. So it takes principles like the right of equality, the right to self-determination, the right to culture, the right to property, and applies those in the specific historical, social context of indigenous peoples to affirm indigenous peoples' equality with regard to other peoples, affirm their right to control their own destinies, affirm the right to continue in relationship with the lands that have sustained them over time, and affirms the right to continue with their cultures intact and to develop on that basis, not simply to be assimilated within the larger societies in which live, have to give up their cultures in order to enjoy their basic rights, but be able to enjoy basic human rights with those cultures intact and with that ongoing, continuing relationship with lands and resources. Suhas mentioned the cases in which I've been involved in the Inter-American system on human rights. These cases illustrate the relationship between indigenous peoples' collective rights, the kind of rights that are affirmed in the Declaration, and basic human rights principles. The Inter-American system is comprised of two basic institutions. One is the Inter-American Commission on Human Rights, and the other is the Inter-American Court of Human Rights. And both of these institutions have as their function the promotion of human rights throughout the Americas, which includes North, Central, and South America, the region that I'm from. And it does so on the basis of two human rights instruments, the American Declaration on the Rights and Duties of Man and the American Convention of Human Rights, neither of which specifically mentions indigenous peoples, but mentions a range of human rights, including the basic right of equality, right to property, right to culture. And what the Inter-American institutions have done on the basis of these cases that have been brought before them concerning indigenous peoples has interpreted these basic human rights principles in the specific context of indigenous peoples. And so when addressing a claim of indigenous communities to their ancestral lands, the Commission didn't say, and the Court didn't say, well, that doesn't concern us because the human rights instruments that we deal with don't mention indigenous peoples. It didn't say that. It took the basic rights of equality connected with the right to property and said, when we look at those rights and we look at indigenous people's own systems of land tenure, those rights affirm their rights to lands, their rights to ancestral lands according to their own cultural patterns. The Commission and the Court took what they called an evolutionary understanding of these principles, these basic human rights principles, an understanding that sees these principles as not simply wedded to Western conceptions of property or equality, but sees them as necessarily part of a diverse world.